Does it ever end with Brian Kohberger?
Agents Taylor. Response, Ms. Jennings.
Yes, Your Honor. Ms. Taylor's argued and multiple completely false narratives are the exact reason why this hearing should be closed. Ms. Taylor's argued and multiple completely false narratives are the exact reason why this hearing should be closed.
Response, Ms. Jennings.
Yes, Your Honor. Ms. Taylor's argued and multiple completely false narratives are the exact reason why this hearing should be closed.
It's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. The names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last-minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state. It's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. The names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last-minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Yes, Your Honor. Ms. Taylor's argued and multiple completely false narratives are the exact reason why this hearing should be closed.
Once the second AT&T warrant comes, then you end up with warrants for Mr. Kohberger's arrest. You end up with warrants for DNA samples to be taken, warrants for the search of his apartment, the search of his car, the search of his parents' house. Those are the warrants that are next implied in that. Here, what's added to that set of affidavits is the paragraph that talks about Mr. Kohberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, I believe it is D1B and C. That's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not. Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records. But based on those records, they absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IgG identification off to the side. But then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking because that's what you're trying to say, and you know that's not true. This court can rely on our proffer in D1B and in the cast draft report and in the cast final report because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that. Comments and understanding where we were a moment ago when we spoke. I feel like I must go through what their disclosures were because there are so many lists. My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at quite a disadvantage, not knowing what their experts would say.
And if they supplement, you certainly can supplement based upon what they supplemented, and I will permit that, and that's kind of the nature of the beast.
I do appreciate that, and should that become necessary, we'll definitely take you up on that, Your Honor. I want to make a record about some of their expert disclosures, though.
Okay.
Completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. The names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
All of the lab people, they have lab reports and notes. The Idaho State Police Forensics Lab, I better be really clear on that. other than the wiggle room language, which would ask that they not be permitted to have any wiggle room language, the lab reports are fine, with the exception of one of the witnesses, Ms. Nowlin, that they've disclosed, and she's written no reports.
Is that the one they said is a rebuttal witness?
They said she might be a rebuttal witness, so I suppose now they know what our witness is going to say. I want to talk about the CAST report. The court's heard a lot about the CAST report. When I say CAST report, that's because that's what it's called. It's really a PowerPoint presentation. There's not any analysis in that. There's just, this will be my testimony. This is what it's going to be. Without much more, it's a picture, and it has some dots and some arrows. Your Honor, that needs to be cleaned up. We need to understand the analysis that went into coming up with those PowerPoint presentations. That's just not plain good enough. I would let the court know that the cell phone experts, there's wiggle language in both of those if the court hasn't seen that. Their disclosure number, that's Mr. Cox, that's a person that has not written a report at all. We have no idea besides the state's disclosure what that person's going to talk about. Agent Douglas that I talked about before, I don't think I need to make further record. There's a lot of documents, no analysis, no opinion stated. We put several of these in our pleadings, and so I won't go through all of them. I'm highlighting the ones that we're really concerned about. We have 3 that looked at digital data. The court should understand there's 60 some devices. There's digital data from third-party sources, and there are 3 people that are listed with just lists of things. It's Mowry, Tanzola, and Uric. They have lists of devices or social media accounts that they're going to talk about. That our expert told us would take 3 years to look at every bit of the data. So having no clue what's going to happen, I can envision exactly what the court's fear is when we get to jury trial, me wondering if this particular thing was ever disclosed. So I definitely needed to make a record of that. Further, with the lab personnel, there's a caveat that says they'll talk about other people's reports and other things that are outside of their report, in addition to some of the other wiggle language that I referred to. Your Honor, given that the state is now cautioned to think about those things and submit more, I feel like it's important for us to bring out that we have a right to confront the evidence that's brought against us. Brian has constitutional rights, United States and state of Idaho constitutional rights for a fair trial and to confront evidence. The expert disclosures are designed to advise us of what the state is going to do. Their disclosures were insufficient. I appreciate what the court said, but exactly what the court's worried about will happen if we don't have better disclosures. The jury will be in and out while we make sure that we have a clean record. We appreciate what the court said today, and we'd ask the court to order the state to comply or for the court to exclude anything that hasn't been disclosed so far. That's it.
So I'm going to give like both sides an example of what I expect so that you understand. There's been talk in this case about DNA. If somebody's going to talk about DNA and your intent is they're going to let the jury understand what DNA is and essentially going to do a mini course on DNA, I expect to see that in the expert disclosures. Not that they're going to do a mini course on the DNA. I expect to see the mini course in the disclosures.
Yes, Your Honor. Ms. Taylor's argued, and multiple completely false narratives are the exact reason why this hearing should be closed.
And essentially going to do a mini course on DNA. I expect to see that in the expert disclosures. Not that they're going to do a mini course on the DNA. I expect to see the mini course in the disclosures, if that makes sense, in terms of what their opinions are, what their information is that they're conveying that is expert in nature. And so it really does behoove both sides to spend the time to do that.
If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. Preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in media. The defendant will get his day in court, and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's fourth and fifth motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Okay, thank you. May 3rd might be a little quick.
Well, Your Honor,
Tomorrow?
right, but our motion was filed over a week ago.
Right.
So everyone's been on notice of what the state was asking for.
Okay, thank you. Thank you, Ms. Daniel. Ms. Taylor?
Thank you, Judge. Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Ms. Taylor?
Thank you, Judge. Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that. What we're going to talk about on the 14th, Judge, I don't have to name any private citizen names. I can talk about records that exist and why we should have them without naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected by the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of such.
That's the thing.
The court would look at Brian's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider this, that this isn't the state trying to protect Brian's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context, but that's what they're doing. When they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us, that is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IGG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Kohberger in it. So that's out there in the public. But that order was to protect information, the IGG information, that they say details how the state got to Brian in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Brian have to have his case, when he's asking for this information, be done in a little vacuum where the state says what the public can hear and what the public can't hear? Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Brian's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that, and that it starts a long time before the little clip that we've received. To do this in a vacuum, Judge, when documents are filed under seal, that's fine. Those are documents, but this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Brian has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public so that people can see it's not this neat little package. So people can start to wonder if Brian's innocent. Your Honor, Brian is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name.
Does it ever end with Brian Kohberger